Hello everyone, welcome to our channel Pakiya. Today in our video we are going to talk about Maritime Legislation Appropriate. So before further any delay, let's get started. When does maritime legislation appropriate? Why are the maritime law appropriate? Most logically, maritime law concerns events which occur on the high seas, accidents that take place far beyond any nation's territorial waters. The territorial sea, which are waters within 12 miles of the shore, is also subject to maritime law. Further inland, however, it becomes less obvious how the law applies. Only in the history of the United States, incidents that took place within the body of the country were not governed by maritime law, thus excluded Great Lakes and non-tidal inland waterway incidents. However, this exclusion started to diminish throughout the latter part of the 19th century. Navigable waters have been governed by the maritime law. A body of water is deemed navigable if, by itself or when connected by other water, it can function as a continuous highway in which trade is or may be carried on to the other nations or foreign countries. As such, a body of water is not navigable for the purpose of admiralty jurisdiction if it is fully landlocked within a single state. A body of water may be deemed navigable despite migrating to other states, though if a body that contains water is a relationship in a network of bodies of water that can be used to aid trade between states, it may be deemed navigable. The final creation is that a straight trade must be able to move across a strait or another country. In the US, the federal court usually had authority over matters involving maritime law. However, today's saving to suitors clause in Title 28 of the United States Code 28 U.S.C. 133 permits state and federal court to hear the bulk of admiralty issues and in dispute involving maritime properties in exception to this rule and must be heard in the federal court. An admiralty case must be tried by the state court while the court must follow admiralty law. It connects to employers' maritime law. Ship owners have a duty to maintain their vessel in line to general maritime law. The vessel owner who serves as the employer is accountable to upkeep the ship's safety and stature in a way that is welcoming to all of the personnel on board. The main duty of a ship owner under maritime law include managing, operating, and supplying the vessel. In turn, the owner will be in charge of any losses if an employee of the vessel is hurt or ill as a consequence of a ship poor seaworthiness. How are hurt workers covered by maritime law? Now, we are going to talk about without maritime law, suffering injured by injured seamen while at work would be left entirely up to themselves. The vessel owner is obligated to shoulder the costs incurred when a ship employee becomes injured or ill. Under maritime law, the employer is obligated to reimburse for the seaman condition up until full recovery, that is referred to as maintenance and care. The ship owner owes thus loyalty to every seaman on board their vessel in the opinion of the court. In addition, seamen are entitled to be given their entirely paycheck for the part of the voyage if they are ill injured. The maximum sum of earned earnings a seaman may receive may be specified in an employment contract. Situation that call named Texas Maritime Accident Attorneys. Houston Maritime Injury Specialists are available for helping injured sailors or dock workers in obtaining the money they require to recover from major injuries and to cover globally treatment. This covers any mishap that take place on docks, harbors, or navigable water, or even in ocean. Our nautical represented clients who ended in jack-up, brig accident, tugboat and bar accident, dock accident involving commercial fishing and false abroad. So, that's it in this video. See you in the next video.